Welcome to the Kemp IT Law vlog. I'm Noreen Ajmal, and this vlog looks at recent guidance aimed at helping Fintech organisations that want to work with large UK banks. The toolkit has been designed to help startups and SMEs in the Fintech space navigate the onboarding process with banks. However, it also includes processes and policies that would apply to any supplier looking to work with large financial services institutions. The guidance is freely available as a publicly available specification issued by the British Standards Institute. It came into effect on the 7th of November 2018 and is a collaborative effort between the UK's leading retail banks, RBS, Barclays, HSBC UK, Lloyds Banking Group and Santander, and fintech vendors like Market Invoice, the ID Company and iWalker. The guidance covers a range of issues starting with the preparation for the qualification process, including due diligence. It explains that the level of due diligence needed will depend on the nature of the technology being provided by the fintech and the level of risk involved. The guidance also sets out key considerations for a bank from a commercial, legal and regulatory perspective. These will include compliance with financial services regulatory requirements such as having appropriate business and technology resilience plans, compliance with laws on anti-bribery and corruption, anti-money laundering and sanction screening, compliance with tax avoidance or terrorist financing laws and rules, and compliance with other ethical policies. As part of the onboarding process, the guidance also emphasises the importance of the fintech, explaining the commercial model being proposed at the outset, such as pricing models, volumes, service levels, and the use of third-party services. Another important consideration for both the fintech and banks in the guidance is intellectual property rights. For example, considering questions like what IP exists and who owns it, who will own new IP that is generated in the course of the engagement, will there be any shared IP, and is there any third-party IP involved? Finally, data protection and information security issues and compliance with GDPR will be a key concern for the bank and will also need to be addressed. The hope is the guidance will help smaller fintechs, particularly startups, work more effectively with established banks, and in turn, this will facilitate innovation in the financial services sector and ultimately will benefit customers. To find out more about supply contracting considerations in the financial services sector, and more generally, check out our vlogs, blogs and white papers at kempitlaw.com.